ජනාධිපතිවරයාගෙන් ලැබෙන සංදේශ මගේ අංකය PS ඇලයිරක් PSA ඇලයිරක් 02 ඇලයිරක් 7 ඇලයිරක් රෝමන් ඉලක්ක 9 ඇලයිරක් 3 ඇලයිරක් 1 2025 සැප්තැම්බර් මාස 22 වන දින ගරු IWM ජගත් වික්‍රමරත්න මැතිතුමා කතානායක ශ්‍රී ලංකා පාර්ලිමේන්තුව ගරු කතානායකතුමනි 40 වෙනි අධිකාරියේ වූ මහජන ආරක්ෂක ආඥා පනත 40 වෙනි අධිකාරියේ වූ මහජන ආරක්ෂක ආඥා පනතේ 12 වෙනි වගන්තියෙන් මා වෙත පැවරුණු බලතල් ප්‍රකාරව මහජන සාමය පවත්වාගෙන යාම සඳහා වන අවශ්‍යතාවය සැලකිල්ලට ගනිමින් පළවෙනි උපලේඛනයේ නිශ්චය කොට දැක්වෙන සන්නද්ධ හමුදාවල සියලුම සමාජිකයන් එහි දෙවෙනි උපලේඛනයේ නිශ්චය කොට දැක්වෙන ප්‍රදේශවල මහජන සාමය පවත්වාගෙන යාම සඳහා කැඳවන බවට ආඥාවක් නිකුත් කොට ඇත. ඒ අනුව උක්ත ආඥා පනතේ 21.2 වගන්තිය සමග කියවිය යුතු 2.3 වගන්තිය ප්‍රකාරව ඒ බව පාර්ලිමේන්තුව වෙත මෙයින් දැනුම් දෙමි.
Most popular biscuit brand
CBL Manchi.
මේට හිතවත් අනුර කුමාර දිසානායක ජනාධිපති කතානායකවරයා විසින් කරන ලබන නිවේදන අංක 1 I wish to make this announcement in furtherance to the announcement made by me on 8 September 2025 on the motion titled the no confidence motion submitted by a group of 32 members of parliament in the opposition, including the Honorable Leader of the Opposition in Parliament, on 12th August 2025 against Honorable Major General retired Andra Jayasekara MP, Deputy Minister of Defence. At the outset, I wish to remind this House the Standing Order 76.1, which states that the Speaker in the Parliament shall be responsible for the observance of the rules of order in Parliament, and his or her decision upon any point of order shall not be open to appeal and shall not be reviewed by Parliament except upon a substantive motion made after notice. However, considering the queries raised in Parliament, I wish to further substantiate the factors highlight in the previous announcement for the ruling the said motion out of order. The 1978 Constitution of Sri Lanka and standing orders of Parliament are silent on moving a no confidence motion against an individual cabinet minister, deputy minister or any other holder of portfolios. The only existing provision on no confidence motion is the Article 49(2) of the Constitution, which provides only to move a no confidence motion against a government. However, no confidence motion have been moved against the Prime Minister, individual ministers of the Cabinet of Ministers, notwithstanding the said silence in the Constitution and standing orders, thus questioning the legal basis of such precedents. It is noted that the parliamentary context, the Speaker, Deputy Chairman of committees, Leader of the House of the Parliament, Chief Government Whip, Leader of the Opposition and the Chief Opposition Whip are considered parliamentary officers bearers, and that a substantive motion of this nature may appropriately be brought against them. I wish to emphasize that in the international context, no confidence motion have been allowed only in respect of the Government Council of Ministers as a whole. A scheme may treatise on law, privileges, procedures and usage of Parliament. 25th edition, and M.N. Kaul and S.L. Sakda, Practice and Procedure of Parliament 8th edition. Further, M.N. Kaul and S.L. Sakda highlight that a motion of no confidence can be moved only against the Council of Members as a whole and not against any individual ministers as per Indian constitutional provisions regarding the collective responsibility of the Council of Ministers of Lok Sabha. Similarly, the Article 42, 43 and 44 of the Constitution of Sri Lanka provides for the collective and individual ministerial responsibility of the Cabinet of Ministers. In Sri Lanka at present, the Deputy Ministers have been appointed under Article 46(1) of the Constitution to assist the Ministers of the Cabinet of Ministers. However, the Ministers of the Cabinet of the present government acting under Article 46(2) of the Constitution have not delegated any power or duty pertaining to any subject of function to the Deputy Ministers. Nevertheless, I wish to place on record that the Deputy Ministers function in terms of Standing Order 32(2) on behalf of the Ministers in compliance of Article 46(1) of the Constitution and read with Article 74 of the Constitution. Due to aforesaid reason, I rule that the motion is out of order in terms of Standing Order 27(3). In the alternate, I wish to note that the incidental criticism of conduct of members of Parliament, or particularly to the members in their capacity as office holders in the House of Commons, including the Speaker, permitted only through a substantive motion. A scheme treatise on the law, privileges, proceedings and usage of Parliament 25th edition, and the UK practice censure motion can be tabled criticizing government policy or a minister. M.N. Kaul and S.L. Sakda, Practice, Procedure and of Parliament 8th edition, states that the censure motion can be moved against the Council of Ministers or an individual minister or group of ministers for their failure to act or not to act for their policy, and may express their regret, indignation or surprise of the House at the failure of the Minister or Ministers. Accordingly, I wish to inform this House to explore the possibility of submitting a substantive motion instead of current motion in issue, in view of the national importance of the matters relating to the Easter Sunday attack stated therein, and so opined by the Attorney General. The specific factors in the motion has no direct bearing to the case pending before courts.